It's a very important month with a Supreme Court ruling that an Indigenous person in the US can come into Canada and exercise rights that are protected by the Constitution. A little bit complex, and that's why Mark Underhill is there on the other side of the screen to help explain. He argued the case up to the Supreme Court. Welcome and thank you for your time.
Oh, good morning. Thank you.
Now, I'm not sure there can be a rapprochement between lawyers and former journalists, but let's give it a try just for fun. The Supreme Court has said persons who are not Canadian citizens, who do not
Just
reside in Canada, can exercise an Aboriginal right. So, and you're in great part responsible for that decision. People like lawyer shows. Could you please summarize your summation and remarks to the Supreme Court for us in plain English? I think
yes,
that'd be fun.
yeah. So, as my client would say, the core truth at the heart of this case from the very beginning was this simple fact that the Sinixt were in Canada as an organized society for thousands of years before the arrival of Europeans. That was never contested at any point by any expert. Indeed, the Crown's expert at trial was the foremost authority on the Sinixt, well-published scholar. And she and Mr. Disotell's expert all agreed this was Sinixt territory. The Sinixt were there at the time of David Thompson's journey up the Columbia. And so that core truth was why this case was won. Strip away all the legal arguments. It's that simple fact, and it's that simple fact which the majority really focused on in saying, that the fundamental question was, as you just said, who are the Aboriginal peoples of Canada? The answer from the court is they are those collectives, societies, peoples who were here at the time Europeans arrived. It sounds simple now, doesn't it? But it sure wasn't for a better part of a decade.
Well, I must compliment you. You do make it sound simple as well. And in many respects, why wouldn't it be simple?
Yeah.
The border long post-dates the Indigenous people's existence on the continent. It's an artificial thing. There was even a dispute, and some Canadians wish we still had Oregon or wish we got Alaska. And in New Brunswick, there is a dispute over Georges Banks, and so there are disputes all over the place. But it does seem just completely logical on the face of it, or as you lawyers would say, prima facie. Were there any intricate legal arguments, concepts that needed to be waded through that the average person should hear about from you in order to fully understand this ruling?
Yeah, so we can start unpacking it a little bit. There was a great deal of attention paid particularly in the lower courts, that this concept that Mr. Disotell could have a right to hunt in Canada as an American citizen would be completely incompatible with Canadian sovereignty. And there was a number of arguments advanced, even to the point of saying that Section 35 itself, Section 35 being the section of the Constitution which protects Aboriginal rights in our country, it itself extinguished the rights, because the idea that these Americans could have rights was completely inconsistent with our Canadian Constitution. So we had endless arguments, various permutations on that argument through the three levels of court before the Supreme Court of Canada. Very helpfully, when we got to Ottawa, the federal government said, you know what, we don't think that issue actually arises, because the question of Mr. Disotell crossing the border was never an issue in the case. In other words, this was about, he had managed to get across just fine, and then was of course able to shoot the elk. That was the centerpiece of this case. And the court agreed with that. That is, the Supreme Court of Canada agreed with that. It said, you know what, for another day is the interesting question of what right does Mr. Disotell have, or Sinixt people more generally have, to cross that border? What restrictions might be able to placed on them, if any, by the federal government? We'll leave that for another day.
Well, let me see if I
Yeah, go ahead.
I mean, very interesting, and sorry for interrupting. It's
No.
youthful exuberance, but it seems to me that it is as you lawyers would say, a spurious and specious argument that something in the Canadian Constitution either bestows rights on Canadians, worse, removes rights from people who don't live in Canada. I mean, that just seems ridiculous on the face of it. Am I right in thinking that it is a spurious argument?
Yes, and that's one of, with the greatest of respect to the province of British Columbia, one of many spurious arguments which were advanced through the course of the argument. The worst crime, if I can just focus on that issue for a moment, that I think was committed, and this leads to a bigger point which the court didn't fully address, is this. I spoke earlier of the Crown's expert who had agreed that the Snakes were, of course, were there for thousands of years. Her thesis, though, was, and this was picked up by the Crown in argument, that the Snakes had, quote, left Canada to enthusiastically embrace farming on the Colville Reservation. Well, for anyone, and certainly all the people who are going to be watching this will know, the idea that Indigenous peoples would give up the seasonal round and their very culture and way of life to, quote, enthusiastically embrace farming is frankly outrageous. But that was the argument, that was the focal point of trial, was the move voluntary or not? And to me, that betrays a fundamental lack of understanding of Aboriginal identity and culture. Because I think, as most people listening to this will know, that tie between identity and land is at the core of Aboriginal culture. In other words, to be Sinixt is to be from that part of Canada, right?
Well, if I may say, it also flies in the face of such things as history. And the notion that behind me is the book Clearing the Plains by a great U Regina professor, Daschuk. And the notion that Indigenous people enthusiastically embraced being removed from their land and put on a smaller piece of land and told to stay there and have a pass to get off it, I mean, is beyond spurious. But now you have articulated the issue there and said that it's what the Indigenous man did in Canada that was at issue, not how he got across the border. And this leads us right into, what do you imagine the future holds on crossing the border? Should Indigenous people still need a passport or an Indian ID card? Or what is the border crossing going to look like a couple of years from now?
Yeah, no, it's a great question. And you can bet there's some folks in Ottawa who are starting to think about those sorts of issues right now. And that's where I guess I'll say a couple of things. One is, I sure hope that finally government will listen to the Supreme Court of Canada and say, these issues don't need to be litigated. They need to be worked out through careful negotiation. And if you think about it, the question of border crossing and border sovereignty, those issues are important. We all would agree as Canadians that that's a very important issue. How that should work in practice surely should be the subject of good faith negotiations, as opposed to yet another battle in the courtroom. And so that's my hope. That's my hope, is we'll sit down and think about those. Because, just if I might, one of the issues that comes up all the time from my clients and people who are calling me these days saying, well, what about citizenship? Shouldn't these folks be dual citizens? And I say, absolutely they should be. Because I've said at each level of court, I've made a grand speech about how Mr. Disotell is far more Canadian than I am. My mother was born in Wales, for heaven's sakes.
Well, by the way, my grandmother was born in Wales, so who knows, maybe we're related, but neither of our names are Jones or Davies or Davis. So, there's something amiss there. But I don't get to one up distinguished lawyers very often, but let me try one upping you, that not only is Mr. Desautel more Canadian than we are, and also more American, but primarily Sinixt, I guess, would be, it's up to him to decide the order of operations.
Exactly.
But most people who are now in Canada live within a day's drive of the border. And many of us, especially my age, remember no passport, no ID necessarily, occasionally asked for ID, very often waving at the border guard whom you knew, and sometimes out for a Sunday drive and cross the border without knowing it, an unregulated border crossing. And many hunters were turned away by American conservation officers or border guards saying, "Oh, by the way, nicely, politely, you've accidentally crossed the border. Go on back." We also have, and this is, I'm not trying to make a speech here. I'm trying to get your reaction. I've also crossed borders using UN identification, not a passport. We have diplomatic passports. We have the Schengen group of countries in Europe, if I'm pronouncing that correctly, where you go back and forth. I crossed 13 international borders in Europe without even discussing anything with a border guard. So there must be ways. What are the ways to let the people who are indeed triple citizens, let's say, of their indigenous communities, Canada, US, how do we get them back and forth across the border expeditiously, as you lawyers would say?
Yeah. Yeah, no, I think it's a great question, and as I say, it should be the focal point of some discussions going forward. And I think, one of the things that the court, which is really yet another important facet of this case. There's so many little nuggets that we could talk about all day, but one of the points the court made is, look, it's ultimately for the Aboriginal peoples themselves to define who they are according to their own, laws, customs, and traditions. And so when we take that concept and we say, all right, it's for the Sinixt people now to go forward, recognizing that there are Sinixt descendants on both sides of the border. So this, down there, this whole idea that they're on this reservation with 12 other tribes by virtue of an executive order, whereas up here in Canada, you've got Sinixt people, members of other Indian Act bands, right, in British Columbia. There needs to be a process of figuring out how that Sinixt identity is going to be put forward by Sinixt people, not by how you and I or the government of British Columbia or the government of Canada thinks it should be organized, but how the people themselves see themselves, how they define their identity, how they define their relationships with each other. That needs to get worked out. And what I'm building to is, once that process has found its way, then it should be, I'm Sinixt, I get to cross the border, I get to be treated just like an American or a Canadian, right? In the same way, again, it's not that you and I get free passage necessarily in this day and age. There are various restrictions that can be reasonably placed, and I wouldn't quarrel necessarily with that being placed on Sinixt people. But why should there be any difference in how Sinixt people are treated? And it shouldn't be they have to go get a Canadian or American passport. It should be, here's, we know who we are, here's who we are, and here's what the court has said about us. We're to be treated just like we're Canadian or just like we're American.
Well, and here, and if I'm not, as the British would say, over egging the cake or overstaying my welcome, I might try to go you one better there and say, if that were not the case, and it is an excellent case you make, but if it were not the case, it would be very similar to the UN or the US or the European Union or someone coming into Canada and say, oh, look here, we've done some research, looked into your files, and we've decided that you're not actually Canadian, so you don't get any of the rights and privileges of other Canadians. And by the way, we think you should move somewhere else. I mean, it would be as ridiculous, wouldn't it?
Yeah, it would. It really would. And so, but that seems to be an awfully hard concept for government to get its head around. It really is. Like, you and I talk about it and we say, oh, it's nonsense to suggest the contrary. But I'll tell you, I just watched the BC government suggest the contrary for the better part of 10 years.
Well, but in fairness, lawyers argue the case they have, even if it's a crummy case, and one is entitled to do that. And so that lawyer was on quite acceptable billable time, and we can thank him or her for service.
Yeah.
But look, am I on the right track with things like UN IDs, the Indian ID, dual, triple citizenship, that type of thing? I mean, there are precedents around the world, aren't there?
There are, and there are lots of borders which are today crossed by all sorts of people, not just Indigenous peoples, but all sorts of different people. So there are ways that can work it out. And we think about you know, there needs to be some kind of ID there. I don't think there's any question about that. But the the big concept for government to get the head around is it's not their ID, it's the people's ID, right? And that's going to take some time to get, you know, worked out. But as I say, I sure hope I don't have to be back in a courtroom fighting about that concept, but rather sitting around a table trying to work it out.
Okay, the questions are going to get harder. So the cross-examination is as follows. All that's well and good. What about Canadian healthcare? Indigenous people from the US, come on up. Under some treaties, they are entitled to what's called the medicine box, and courts have ruled that that means, you know, pretty decent healthcare, not an actual medicine box. And under the Indian Act and under precedents, it seems pretty clear that Indigenous people are entitled to a bit of an upgrade from Canada's National Health Program, or at least that kind of program. So how's that going to work?
Yeah. Well, you know, one of the interesting questions for the Sinixt people to work out is to what extent, because remember, what you're talking about is a move en masse, not everybody, but a vast majority of the population moved south, not again of their own volition, of course, in about 1872. So you've now got multiple generations having, you know, lives in Washington State, if I can put it that way. So one of the things that's going to be interesting to figure out is, you know, to what extent are the Sinixt people able to, you know, reside long-term in the territory and therefore be of need of those kind of healthcare services. And so I see that more as a long-term issue.
Well,
but again,
unless,
I go back,
but
yeah,
unless you have a medical emergency and pop into
yeah,
an emergency room or go see a physician, then it could come to the fore a little more quickly than you're
yeah,
predicting.
it could. But again, that should not be, I mean, what we're not talking, first of all, about a lot of people in the case of the Sinites. But in any event, even if it were a lot of people, you know, the answer is always the same. Even if the questions do get tougher, I'm going to come back to the same answers, which is, well, look, they were here for thousands of years. They have every right to be in Canada and to be treated like any other Canadian in terms of their entitlement to healthcare. And why would we quarrel with that? Right?
Yeah, and one assumes it's a pretty obvious assumption that if people were living here for thousands of years and migrated and traveled and went for seasonal purposes to other places through other people's territories, that they had a system of laws and a system of border control that you know, seemed to work for them.
They did, and I'll use where my clients were on Friday morning as a good example of that. So where my clients were in Washington State was a place called Kettle Falls. Kettle Falls was, back in the day, the second largest fishery on the Columbia and one of the major economic centers in North America. You know, the archaeology has found various artifacts from the east coast of the continent. And the point there is there was an extraordinarily elaborate system of governance and laws that allowed all these various nations to come and fish at this. You know, the Columbia was the most productive salmon river in North America, dwarfed our Fraser River in Vancouver here. And so you think about what was required to govern the operation of that fishery and the trade that went on there. I think they're more than capable of working these things out in this modern age.
Okay, tougher question. There would not be the prosperity in British Columbia that there is if it weren't for WAC, known as Wacky Bennett, and the Two Rivers policy, the damming of rivers to generate electricity. Some of that is in the territory of your clients. How do they get to share with that? How do they get to share the prosperity?
Yeah, that's right. And so that is it is a hard question, and but it is a point we'll be pursuing, because here's what I want to talk about. Not only you know, are all the economic benefits that have flown from that that have not been shared with the Sinixt or anybody else over many decades. That's a thorny issue in terms of negotiations to come. But one, I know my clients would be unhappy if I did not say those dams also stop the lifeblood of the Sinixt people, that is the salmon, from getting up into Canada. And so salmon passage, I can tell you, is also, it seems intractable right now, but it seemed intractable to Snipes were going to be able to come home, and here we are. But I can tell you the salmon coming home is a top priority for the Snipes people.
Well, and there are people, not just lawyers, but environmentalists and many others who've been studying this issue who say that the biomass downstream from small dams that are maybe 7,000 of them around North America, perhaps, is far more valuable than the power generated by the dam. And even those big dams, such as, is it Site C that's under consideration now in British Columbia?
That's yeah, and just had a COVID outbreak actually at it. Yeah.
And many people are saying, look, we have other methods of generating power. These are too expensive. They go way over budget. And so that is going to go into the mix in the debate, I'm sure.
Yeah, no, that's exactly right. And that's a debate the Snipes want to be front and center on, at least for those dams in their territory. You know, places called Keenly Side and Juanita are the some of the dams we're talking about, and those conversations need to take place.
All right. Now, the best laid plans of mice and men, let's say. You know the Marshall decision better than I do. The Supreme Court said that Donald Marshall Jr. And his Mi'kmaq people and many other Indigenous people were entitled to a commercial livelihood fishery, if I've got the right words. That has been circumvented. Weasel words have helped circumvent it for 22 years. Even the courts have said the Department of Fisheries and Oceans is wrong to interpret that as meaning the Indigenous people's right has to be shoehorned into common commercial fishing practices, such as buying an old boat, buying worn out equipment, and buying a license. So even the Supreme Court ruling seems to have been circumvented by what some would call the administrative state, the people administering this kind of thing. Do you anticipate having to be vigilant to make sure that this ruling is adhered to in a proper way? Do you see ways that it could be circumvented? Because I sure do at the border, as we discussed.
Yeah, no, I think there's a myriad of ways that this ruling, there's a long what is it, inglorious history of government ignoring these decisions, both at the federal and provincial level. You know, every decision that comes along, well, nothing's really changed, and the status quo has been maintained throughout. You know, including cases. You know, our last big title case here in British Columbia was the Chilcotin case. And if you go talk to the Chilcotin, they will say, we have not achieved what we believe the court said we're entitled to. And so it's an ongoing battle that requires a great deal of vigilance. I have no doubt this is not going to be an easy path going forward.
Well, it's not quite as insidious, I don't think, but you can correct me if I'm wrong, as American voting. Yes, Black African Americans got the vote, provided they could guess the number of bubbles in a bar of soap or other ridiculous questions, and that there needs to be vigilance in that area as well, I'm sure.
Well, I mean, just look what's happening south of the border, right? Look, I mean, you know, you have the return of Jim Crow voter suppression, right? Nakedly and transparently in the state of Georgia in 2021. Yeah. So, you know, that tells you everything you need to know.
Now, for anyone watching this from Saskatchewan, the last lawyer that I got to speak to who argued a case in front of the Supreme Court is the late Morris Shumiacher, a great local figure. And he once got someone off a traffic ticket by arguing that the Albert Street Bridge was not a bridge, it was a dam. And he was famous for that case as well.
That's great.
Give me some inside baseball. Did you actually go to the Supreme Court? Did you do it on Zoom? You wore robes, I assume. You know, give us a flavor of arguing a case like this in front of the Supreme Court.
Yeah, it was, we were lucky in this sense that we were able to attend in person, first of all, because that was just before the second wave had really overcome our country. And so this was early October. Now, Ottawa was eerie, I have to tell you. So I flew into Ottawa a few days early, as one does, to sort of, you know, prepare and get ready. And it was pretty, you know, nothing was open. It was at least nothing was open after 4 o'clock. And so it was very interesting times, but we were all out of kilter because what was happening was you were only basically 2 or 3 lawyers were allowed in the courtroom at one time. Usually you're packed in there like sardines. You've got a full gallery behind you, and you've got upwards of 20, 30, 40 lawyers. We had 17 interveners, I think, all told, actually more than that, close to 20. And it was very unusual watching, for me, for example, because I of course went later after the Crown went as the appellant, watching the Crown on a big video screen in another room, and then being sort of ushered in when it was my turn. And so that was an unusual experience, which is, sort of that hybrid between video conferencing. And so it was, everyone was a little out of kilter, I would say.
Well, that sounds like normal life to me because I grew up on
Yeah.
television, but it's another
Yeah.
story. And one of the interveners was my dear friend Paul Williams, who acts for the Beskoton Makati. Were there any people intervening against?
Well, we had 7 of the attorneys general against. One, UConn was actually mostly supportive, but no, we had, you and I talked earlier about some of the, what I view at least as spurious arguments that were advanced by the Attorney General of British Columbia. We saw some of those resurface in the Supreme Court of Canada arguments by provinces like Alberta, for example.
It's always fun for a lawyer to misquote a journalist because usually the accusation is the other way around. For the record, I called it specious and spurious, and I will add fallacious just for the record. And if you read back the transcript, I think you'll agree that I was correct. There's no particular reason to be fair to those who argued against, but could you summarize the dissenting judge's opinion?
Yeah, so we had 2 dissenting judges in this case, Justice Moldaver and Justice Cote. Justice Moldaver said, well, in terms of the big question of the Aboriginal peoples of Canada, he sort of said, well, the majority is probably right about that, but I'm not going to sort of officially say they are. And then what I struggle with, to be blunt, with the sort of the main reason they dissented is they said, we don't think Mr. Disotell has made out the concept of continuity. That is, that we think the fact that there was this break in hunting in the 20th century defeats the rights claim. And I have a huge problem with that at a couple of different levels. First of which is the Supreme Court of Canada, with all due respect, should not be wading into the facts in the way the dissent did. And second of all, but thankfully, the majority said, that's not what continuity is about. We've never said you have to have this unbroken chain of continuity, because how could any group ever establish that? If you think about what was happening to Aboriginal peoples in the 20th century, being able to carry out their culture was specifically prohibited and made illegal, at least in the province of British Columbia. No feasting, no ability to raise money for Aboriginal land claims. The list goes on.
Well, but let me again try to double down and say, I have a right to free expression via the Constitution, but that doesn't mean I have to keep babbling away all the time, or writing, or having commissioning skywriting by airplane, whatever free expression means. And Chief Justice Dixon has said it might be cabs driving around City Hall protesting gas prices or something. So whatever expression is, surely I don't have to be continually expressing myself, or that right is extinguished. If you choose not to hunt one year, or it's a bad hunting year, or you're forbidden, or whatever it is, that does seem to be irrelevant, doesn't it?
It does. And let me add what my favorite part of this case from a pure historical perspective. In 1896, Victoria passed a law. So the seat of government, BC, is in Victoria on Vancouver Island. Always been a bit of an odd thing. But in any event, they passed a law in 1896 to make it illegal for, quote, non-resident Indians to hunt in the province of British Columbia. Why? Because there was such an uproar in the West Kootenays, which is, anyone who knows British Columbia knows, that's still kind of a long way from Victoria, right? And relatively remote to this day, difficult place to get into. And so to me, it's remarkable that there was sufficient unrest by, of course, still kind of a bustling mining, even at that point. You're past the heady years of the gold rush at that point, but still a booming area for mining and settlement, obviously, more generally. So much unrest because of the Snipes coming up to carry on their seasonal round. I remind you of, enthusiastically embracing farming when I say that. They're still coming up so much, they pass a law in Victoria. So my point is, it was illegal for them to hunt during the time period which the minority said, well, they weren't hunting then, so no right. To me, I had a bit of a discussion with Justice Moldaver on this very point, and I said it was illegal for them to hunt. And you're going to say, well, no right, sorry.
Well, that's almost like saying to African Americans in the U.S. Deep South that you have relinquished your right to vote because you didn't vote because you couldn't guess the number of bubbles in the thing. Now, you've surpassed my knowledge of legal procedure, which is not hard, but you said that the Supreme Court should not have been opining on matters of fact. It was matters of law that they should have. Could you explain that distinction?
Their job, particularly in a case like regulatory prosecution, is expressly to consider the questions of law. It's for the trial judge to make the findings of fact. And my point is, absent palpable and overriding error, which is the legal term we use. In other words, unless there was some egregious error, there was no evidence upon which the trial judge could have made that finding of fact. All appellate courts, but particularly the Supreme Court of Canada, are to stay away from the findings of fact. And my point is, there was no argument by the province of British Columbia that any errors of fact had been made, let alone one about continuity. So there was no even argument before the court. And so the court, respectfully, should not have been wading into and revisiting the evidence on continuity. Now, thankfully, sorry.
Okay, so the dissenting opinions were either weak, as you said, with one justice, or, as you lawyers would like to say, ultra virus out of their purview, right?
Yes, no. And so what I take some comfort in, thinking ahead to what might happen in future cases, is you do have a very strong majority of the court saying, that's not how we think about continuity. We don't mean you have to show that you kept practicing that right year after year after year through the course of time.
And doesn't that raise the natural law argument that rights are not something that is bestowed upon citizens or residents by a government or by the administrative state? They also aren't taken away. They existed long before governments had existed, and the argument for, or the task for governments, is to preserve and protect those rights, not give and take them away.
Yeah, without getting too deep into legal theory, but the court actually, again, in this case, made the point that, look at where do these rights come from? They don't come from our Constitution. They come from what we talked about earlier, the pre-existing practices, customs, and traditions. So we didn't create them. The Constitution didn't create them. Judges certainly didn't create them. It's those practices which existed. And that's why this notion of having to prove that you kept exercising that practice through the course of time makes no sense.
Now, I'm also reminded, and it's just because things pop into my mind, of the Rathwell decision, the so-called farm wife in Saskatchewan, whose case went right to the Supreme Court, and this is the basis of dividing community property these days. My recollection is that was a split decision. That was 5-4. But it is still the law and the practice and the custom, and known as equitable and reasonable and fair. And anything else would appear to be ridiculous today. So this ruling is a much stronger ruling than that one, isn't it?
Yeah, it is. Now, again, the nice thing about the Supreme Court of Canada, it doesn't really matter what as long as you've got the 5, you're good, right? So 5-4 is just as strong. What we lawyers worry about is, well, 5-4 is close, and something might change and the next case might go another way. Here, I think it is safe to say, when you had essentially almost 8-1, really, in terms of the big picture, issue of who's an Aboriginal peoples of Canada, it will stand the test of time. And there's a number of other important points that I think will stand the test of time as we move forward.
Now, even though I can't see you in person, you look young enough on Zoom to be dealing with this case in the years to come. I assume you are anticipating dealing with similar cases or the outflow of this case. Is that right?
Yeah, no, I think it's fair to say there will be there'll be lots of work for lawyers across the country flowing out of this. But as I say, I do sincerely say I hope it's not in the courtroom, and I hope it's lawyers helping clients sit down for good faith discussions. Now, I say that having seen what has happened after each of the victories by Indigenous peoples at the Supreme Court of Canada. It's a healthy degree of skepticism I think we all have. Nonetheless, the court was once again very strong, saying sit down and negotiate these issues.
Well, given where you are, I hope you celebrate with some indigenous produced wine from Osoyoos. It's some of the
Yes,
great red there is in the
yep,
universe.
that's
And
right.
next time you're in Washington State talking to your clients, there's very good wine in the Willamette Valley.
There's some
So
excellent Pinot to be found in that part of the world.
yeah, so I commend that. Now, I always leave room at the end for a question that I forgot to ask or a statement you want to make. And sometimes people use that time to criticize me or get even or something. So the floor is yours for the next minute.
Well, thank you. No, I think this has been a great conversation. I appreciate you doing this. I guess the point I wanted to leave with you, Friday for me was such an emotional moment getting to tell the clients who, people have been waiting their whole lives for this. Most thought the day would never come. And as I talked about earlier, what I'm reminded of at the core of the case was always that point as well. That's where we're from. It's who we are. So how can this be any other way? And I want people to remember that's it's no more complicated than that. Our ancestors are buried there. We define ourselves by the fact that we're from that place. To be Sinaiks is to be the people of the place of the bull trout. And reciprocally, the Arrow Lakes get their name from the fact that the Sinaiks people were shooting arrows in a cave, which I'm desperately trying to find with the help of some experts. So I want people to remember that connection. You can't break that connection.
Mark Underhill, great constitutional lawyer, successful arguer in front of the Supreme Court. Thank you so much for your time. I appreciate it.
Thank you very much.